Oh, well, look who it is. I'm so glad you could come back. Because I've got some more real property I'm going to be dragging you through. Now, what we're going to talk about today is going to be rights in real property. Now, this is going to cover restrictive covenants, easements, profits and licenses, fixtures, and zoning. Because we always got to make sure we zone properly. We've got to figure out how to fixture those easements and covenants to where they can run with the land, as well as how to get rid of them. So let's start off with restrictive covenants. Now, some great mnemonics exist, but first you have to remember, CIA, they're not just watching you in the world, but you can use them to know about notice. So the CIA stands for constructive notice, inquiry notice, and actual notice. So remember, notice will require the CIA. So let's start off with restrictive covenants. We're going to make sure that we grab a pint and it can come in a can. And what this means is to set up a restrictive covenant, you're going to need privity of estates, intent by original contracting parties, that covenant attached to land and to run with future assignees. In other words, horizontal privity. Then you have notice. Remember, the CIA is how you know there's notice of restrictive covenant. Then it has to touch and concern the land. Then you can't forget, whenever you have a pint, you should have more than one and include the statute of frauds for that S. So for pints, it's privity of estate, intent by original contracting parties, that covenant attached to the land and run to future assignees, CIA notice of restrictive covenants, touch and concern the land, and statute of frauds. So let's go grab that pint now. Now, I also mentioned that pints can come in cans. So, they can be imposed by common owner to protect lands retained, covenants agreed to by the adjoining landowners or neighbors, imposed for benefits of neighboring lands, or to carry out common plan or scheme. Now let's go ahead and talk about what types of things can make a covenant and what that means. So there are real covenants, equitable servitudes, implied reciprocal servitudes. And a real covenant is a promise concerning the use of the land that runs to successors of the promise. Now, I know you're wondering, well, what does that even mean? I mean, that just sounds confusing. Well, put that dry biscuit back down. What it means is that with a covenant, you're either required to do something or you will have to refrain from doing something. So, if you're benefiting from the covenant, it means that you get the ability to enforce it. However, if it's a burden from the covenant, it means that you're subject to it or bound by it. It's important to know what binds you. And that's how you understand what a real covenant is. So, you heard that there's some equitable servitude going on here, right? Well, an equitable servitude operates a lot like a real covenant, but it has easier requirements. So the main difference between a real covenant and an equitable servitude is really the remedy. And remember, we do love our remedies. Hair of the dog is the best remedy there always is. So the remedy for a breach of a real covenant is money damages. Now, the remedy for a breach of an equitable servitude is an injunctive relief. Moving on to implied reciprocal servitudes. Now, don't ask me to say that 3 times fast after I've been drinking me my tequila. Now, implied reciprocal servitudes arise usually in planned subdivisions. And most jurisdictions impose a certain requirements on these servitudes. So there must be intent to create a servitude on all plots. You can't just say, well, some of these here and some of them there. No, it has to be on all of them. All of them. The servitude must be negative, which means a burden. It has to be burdensome. In other words, you have to be refraining from doing something. And finally, the party against whom enforcement of the servitude is sought must have actual, constructive, or inquiry notice. So they must know about who? Now, who must they know about? The CIA. The CIA must have notified them. They never notified me. I guess I'm not important. Anyway, it's important to note that reciprocal negative servitudes are implied from the common scheme. In other words, it does not require to be in writing for an equitable servitude. It can be created by implication. And since we are talking about creation, you can glean from the nature and type of each of the covenants how they're created. Generally, it requires some kind of agreement between the parties. Now, since the only one that does not have to be in writing is the implied reciprocal servitudes, we understand that because they have to be in writing, there has to be some form of agreement for a covenant to exist. If you recall, earlier I mentioned that we may want it to run with the land, future assignees, in order for that burden to run with successors of the land, there's certain elements that must be present. So, we're going to talk about a benefit first. So, what does it mean if it's a benefit? It means that you get to enforce the covenant. We love being forceful and enforcing things. So, in order for a benefit to run to successors, the following 4 elements must be present. Can we count to 4? Have we gotten that far? So, it must be in writing. So, the covenant must be included in writing in the original conveyance. It's got to satisfy the statute of frauds. Now, there has to be intent. The original parties must have intended for the covenant to run with the land. Remember, that's part of our pint. Now, touch and concern. The covenant must touch and concern the land. Now, you're probably wondering, well, what the hell does that mean, Kimmy? Touch and concern the land. Well, honestly, that's just rude. It means that it's usually by increasing the value of the land. You want your land to make more money, don't you? I know I do. Finally, there must be relaxed vertical privity. Relaxed vertical privity? Huh? What that means is the successor need only take an interest that is carved out of the original party's estate. In other words, you don't have to take the whole kit and caboodle. You can just, take less than the original party's entire estate in the property. So, a good example, a life estate from a fee simple. Now, what if you're the unfortunate, that poor unfortunate soul who is the burdened party? Well, in order for a burden to run to successors, you have 6 elements. 6. That must be present. You've got to have it in writing. So, they still got that old writing it down bit. You still have the intent. You still have the touch and concern element. You still have the strict vertical party. We love us some vertical. But you also have horizontal privity. So, the instrument used in the conveyance of the property, it must include the estate and the covenant. So the covenant has to be in the deed. And then the final part, the CIA has to get involved again. Now granted, I don't mind when the CIA gets involved because they look good. Oh yes they do. They look damn good. But the CIA has to get involved, which means we need what? Notice. And that is the 6th element. Notice. So to recap, if you are getting the benefit of the covenant, you need writing, intent, touch and concern, and relaxed vertical privity. If you are burdened by this covenant, you need writing, intent, touching concern, strict vertical privity, horizontal privity, and notice. Moving right along, we're going to talk about easements, profits, and licenses. So, you have to remember there are laws against negative easements. And since you're studying to practice laws, you should know them. The laws against negative easements are light, air, water use, and support. So, lights for easement, light easement, easement of air, water use easement, and easement of support are against negative easements. Now, if you happen to have a crab on your property, and you aren't, Ariel living under the sea, you might have an implied easement. Now you're going, well, Kimmy, but why do I want a crab on my property? Well, crab, it stands for both common and serving estates were formerly held by common owner. And what this means is essentially both properties used to be part of a whole that was split by one owner. Or the use of the implied estate's the use of the implied easement is reasonably necessary for use of a dominant estate. Now, what this means is if I have to cross Betty Boop's yard to get to my home, well, that's reasonably necessary if there is no other way for me to get to my home. A is the use of the easement was plainly and physically apparent from inspection of the land. Now, there is an exception for this in the implied easement for underground water pipes. We like you to have your water. We don't want you smelling them. And finally, B is the former use of that land subordinated one part of the land for benefit of another part. Subordination? Well, I'm just usually against that. But in this case, I'll make an exception. Now, what all of this is really telling you is that pigs create easements. And a cow can partition realty. So if you're needing that easement, you best be getting the pigs. What? You want to know what PIG stands for? Oh, right. PIGS means prescription, easement by implication, also known as quasi-easement. G is for easement by grant. And S is an easement by strict necessity. So pigs create easements. Again, we have prescription, easement by implication, otherwise known as a quasi-easement, easement by grant, and then an easement by strict necessity. You want to know why we don't like cows here? Well, a cow can partition your realty. I don't know about you, but I like my realty to stay in one piece. So the way the cow does it is by a court decree, an oral agreement between all, of the co-tenants provided they all go into possession. And in case you're wondering what all means, it means 100%. Entirely. All. The whole kit and caboodle. And then W is the signed writing voluntarily partitioning property by exchange of deeds signed by all co-tenants. Again, we have that word all there. Okay? That's why we don't like cow here in property. That's why you shouldn't have a cow. Have some pigs. Oh, one more thing. The following two interests are not easements. A profit is a right to enter another's land to remove a specific natural resource. So if you've got the right to go logging on somebody's land, that's a profit. Now, a license is a revocable permission to use another's land. An example would be a ticket to a music concert. We do need to have more music concerts. Armed with these mnemonics, let's have a discussion about some different types and their natures. First, we have affirmative easements. Now, this is an easement is held by one person to make specific limited use of land owned by another. Most easements are affirmative, giving the holder of the right to make affirmative use of another's property, such as crossing another's land to access a highway. Why on earth would you want to access highways? That implies you have to go somewhere. Ugh. Then you have an implied easement by prescription. Now, this is created when a landowner allows a trespasser to use their land continuously for the statutory period. So, for this, the trespasser has to be hostile. Now, that doesn't mean they have to be threatening you. It means they have to be doing it without permission from the owner of the land. It has to be open and notorious. In other words, it can't be hidden. They can't be sleuthing through the woods at night. And it has to be continuous for the statutory period. Now, it's worth noting, unlike adverse possession, which we will get to, calm your titties, the use need not be exclusive. An example would be public easement to access a beach. Now, an express easement is created when the grant arises, when it's affirmatively created by the parties in writing that is in compliance with the statute of frauds. We like the statute of frauds. Now, it can also be created by reservation. An express easement by reservation is created when a grantor conveys land but reserves an easement right in that land for their own use. So say I want to give you some of my property, but I know I'm going to need to still traverse that land to get something. Well, I might reserve that easement when I convey it. Next, we have easement by implication. Now, if the owner of two parcels of land previously used one parcel to benefit the other, then the court may find that upon the sale of the dominant parcel, the parties intended the easement to continue. This will normally occur if the prior use was continuous, apparent, meaning open and obvious, and reasonably necessary to the dominant land's use and enjoyment. You'll recall I also talked about the easements of necessity. An easement by necessity is generally created only when property is virtually useless. Yes, just like that ex of yours. Virtually useless. Without the benefit of an easement across neighboring property. Oh, before I forget, in addition, for an easement of necessity to be created, in the past, both the dominant and servient estates must have been owned, must have been under common ownership. And the necessity must have arisen at the time the property was severed, creating the two estates. So, I know you all have been pining about creating your very own easements. And to pine for an easement creation lets you remember that you have to have prescription, implication, necessity, express, or estoppel. So those are the ways that you can create an easement. Again, prescription, implication, necessity, express, and estoppel are the way you pine for an easement. Now, if you need an easement by implication, you need to cran. And no, we're not talking about the berries. It is not Thanksgiving. There are no cranberries. It's just cran. So, an easement by implication means it needs to be continuous or permanent prior to use, reasonably necessary, apparent under inspection, and no practical alternative route. That does not mean there needs to be no other route. It means that there needs to be no other practical route. And that's how you cran your way into an easement by implication. Now, if you'd like to be prescribe your easement, you don't go see a doctor. You go see Joe. Now, Joe means continual possession for statutory period, hostile to true owner's interest, and open and notorious. So by going to go see Joe, you can get an easement by prescription. Now, if we're going to be looking at an easement by necessity, we're going to have to look at the scope at which it's determined by. And it's determined by the extent of the necessity. Now, an easement by implication is determined by the existing quasi-easement. Now, if for any reason there's a change in the scope, it's tested under a reasonableness standard in light of the purpose of the easement. So if it needs to change, you see at what purpose the easement was doing and see if it's reasonable for it to continue. Now this leads us into some fun mnemonics that'll help us extinguish some easements. Now, the left ramps here, the ramps on your left, the L ramps, are gonna help you understand some terminations. You've got lack of necessity, release or estoppel, abandonment, merger, physical blockage, and severance. And that's your left-hand ramps, or your L ramps. Cramming can also extinguish easements. Now, not just cramming, but a cramming. Title, different application. You've got abandonment, condemnation by state's exercise of eminent domain. We're going to avoid that until we get to the Constitution. No, we'll end up talking about here soon. But be patient. Signed writing releasing the easement, adverse possession of servient estate in hostile manner, preventing the easement's use. Merger by common ownership of all. That means 100%, I know, math is hard, of dominant and servient estate. Because one can't possess an easement, covenant, or profit on their own property. You can't make money off yourself. At least not in real property. So as a quick review, an easement may be terminated by release, merger, abandonment, prescription, sale to a bona fide purchaser, estoppel, and end of necessity. That's how you'll A-cram and left ramp your way through those easements. Let's turn our discussion now towards fixtures. No, I'm not just talking about going into Lowe's or Home Depot and seeing what new faucets and shower parts we can get. No, no, no. A fixture is a tangible personal property, chattel, if you will, that is attached to real property in such a manner that it is treated as part of the rest of the real property when determining its ownership. As far as determining what that means, that intent is judged by applying an objective, reasonable person standard that examines some factors. First of all, what's the importance of this chattel to the real property? Whether that chattel was specifically designed for use on the real property, and the amount of damage that removal of the chattel would cause to the real property. Now, a point of note here. Structures built on real property, like walls, and materials incorporated into a structure, basically bricks, cement, wood, become part of the real property. The owner of the real property is generally also the owner of any structures on the real property, including the materials that you incorporate into those things. Now, for fixtures, if you want to understand if it passes with the real property, it's important to follow the damn factors. It's very important. It's damn important. And damn means we have damage the removal would cause, adaptation of item to realty, manner in which it is attached, nature of the item. And that's how we get the damn factors. And for all you doing commercial properties, trade fixtures are chattels that are used in business. They are not considered fixtures. We're going to continue the discussion today with some zoning. Now, who's in charge of zoning? Well, that'd be the states. The good old states. Now, it's important to follow the zoning restrictions and regulations implied by your state. Now, if you are developing or have a unique hardship, you can get what's called a variance from an ordinance that may be granted by showing that you have a unique hardship. Now, many zoning ordinances protect a pre-existing use. So if you were already using it for that purpose and they change the zoner on you, you're okay usually. Always good to check, but you're usually okay. Now, it's important to note, as soon as the property is sold to a new party, the pre-existing use is no longer protected. Now, property associations, owners of lots, agree to contribute to the support of common property. Now, in order to create it, there must be a master deed and privity between the original purchasers and the developer. And these restrictions generally carry a presumption of reasonableness and usually are enforced. Now, I bet you're wondering, why is that under zoning? That sounds more like, the covenant we were talking about earlier. Well, yes. But those covenants can also act in the same deed as zoning laws. Think of your homeowners associations. They're not just all no's and Nancy's. That is a form of zoning. Because as a community, you are deciding what you want in your association. And most zones of urban development are massive plots of land with a master deed. And that's how they can create those homeowners associations.